Let's get this next one in here. We got Fani Willis up in the building, and Fani Willis isn't in the courtroom today, of course, because y'all know Fani does not like showing up for court. But we've got Judge McBurney, and he's actually going to have a hearing in reference to what was going on between Fani Willis and the Judicial Watch. As we know, Judicial Watch was trying to get some documents from Fani Willis in the DA's office under the Freedom of Information Act. Fani Willis went back and forth. She said, no, we're not giving you the documents. Judicial Watch, they said, all right, well, we're going to sue. They won the lawsuit. Fani Willis, well, me, Amy, Mr. Tesla, and several of us here in Fulton County are going to have to pay Judicial Watch $20,000+ because Fani Willis and her office didn't follow the Freedom of Information Act. Now we've got Judicial Watch versus Fani Willis here in front of Judge McBurney, and he's going to talk about what's going on back and forth, what Fani Willis needs to do, and he's actually going to get into some of the oversight that's happening in this case. And he makes some interesting statements about how Fani Willis in the DA's office has been processing some of these requests. Let's go ahead and get into it, see what they're talking about.
Need to hear from you. All right. Then let's get on the record. This is 24 CV 002805, Judicial Watch versus the District Attorney, Ms. Willis. And we are here to talk about next steps in the case. This case was brought when the District Attorney's Office, I found, failed to comply with an Open Records Act request that Judicial Watch had filed.
Garbage.
And we've learned a fair amount about the efforts that were and were not undertaken by the District Attorney's Office to comply. And we reached a point where I entered an order that set a deadline for the District Attorney's Office to actually do what it was supposed to do a while ago. And in doing so, the District Attorney's Office identified a universe of documents that would otherwise comply with the request, or were responsive, I guess is the way to put it, responsive to Judicial Watch's request. But the District Attorney's Office contends that those records or documents are exempt or accepted from production under the Open Records Act because they pertain to an open investigation, or they're privileged, as in attorney-client privilege, and or they are attorney work product. Mr. Monroe, on behalf of his client, has filed a motion for an in-camera review of those records and or the appointment of a special master. And representatives of the county attorney's office representing the district attorney have expressed their view on what the right response is as to where we are. And I'm happy to hear from both sides now. I'm going to start with you, Mr. Monroe. But let me tell you what my initial thought is as to how we handle this. I think I can appoint a special master. I think that Rule 46 empowers me to do that. I appreciate that the Open Records Act doesn't speak to it, but it certainly doesn't prohibit it. And there's nothing in Rule 46 that says special masters shall only be used in situations outside the realm of the Open Records Act. But that's an expensive proposition. It would be an expense borne by both sides, not just one. And I don't know that it's necessary. And that's what I'm going to want to hear about more. In a little bit, you're doing some shadow boxing, Mr. Monroe, because you don't know what's out there. And I think that's part of your client's concern. But my initial thought was that I hear, and it may not be that I hear in open court on the record, but that I receive information from the district attorney's office through counsel for the district attorney's office about what that universe is. And if it's 55 pages, we don't need a special master. I can do that. If it's 5,500 pages, I'm not looking at 5,500 pages. Well, I will, but I'll get that done over the next 4 years. And that's not helpful to anyone. So we would need a special master because she or he could devote the time, because she or he would be getting the money to devote the time. So that seemed to me like the first hurdle is, well, let's figure out really how big this universe of potentially exempted records is, how big it is. That doesn't address, though, your concern. That's why I want to give you the voice in just a moment well, that's what came up when they really searched, when you told them they had to. But what about Mr. Bond saying, I didn't look at people's cell phones, I didn't do this or that? Then I would be reviewing an incomplete universe. So we'll need to.
So Fulton County, let me know what y'all think, because I know a lot of you who are here in Fulton County with us are watching. Let me know what you think. Do you want a special master? Do you want to pay for that? I know I do. Let's get it done.
Work through that. I'm not sure I'm going to be telling anyone they have to hand over their cell phones, but I am going to listen to you about what you think ought to be done. But I don't mean to get ahead of myself. Why don't we get the entries for the two sides on the record? I know we've had a little bit of a rotation on the defense side. So on behalf of Judicial Watch, we have
John Monroe, Your Honor.
And on behalf of the District Attorney, we have.
Good afternoon, Your Honor. Brad Bowman
And Deidre Thomas.
Hi, Ms. Thomas. Hello, Mr. Bowman.
Shout out to Jim.
Before we dive into it in the way I described, is there anything procedurally, Mr. Monroe, you want to go over?
May I remain seated so I can stay by the microphone, Your Honor? Is that all right with you?
As long as Ms. Taylor can hear you, I'm fine with that. Let's make it easier by adding you, and you can move the screen around if you want to be more centered in the screen. And then we've got a screen with the lawyers for the DA on there as well, so Ms. Taylor can see all that. And she gets the bird's eye view of the courtroom. So you can stay right there. Procedural matters.
I'm not sure, Your Honor. I just want to point out, I think this hearing was noticed for both the in-camera inspection and or the special master appointment. I'm not sure what we can do today about the in-camera inspection, because one of the issues we have is there wasn't a privilege log or anything else associated with it. I suppose that the defendant could just hand over everything they say is responsive and you could sort through it. I think that would probably be doing a disservice to you if they didn't start by at least identifying what they have. And as they pointed out in their brief, one of the things that could be done is a hearing to determine, based on their description of what they have, whether it might even qualify, because we might.
That could be done. I don't know that it has to be done, and I'm not interested in compelling the district attorney's office to describe things, especially where one of the categories is open investigation. So I'm very comfortable starting the way I described, and I didn't mean to suggest if we mislabeled the notice for this hearing. Today is not the day for the in-camera review. Today is the day where we talk about what's the next step. And I have fronted my view that what I see as the next step is for Mr. Bowman and Ms. Thomas to get to me an overview of this is the universe of the things that were withheld. And to me, I'm much more interested in numbers rather than descriptions, because if the total universe, to include things that the district attorney insists are privileged, is 12 documents and the page number is less than 100, I can go through that. I can figure out for myself what I think ought to be disclosed and not. And then we can go through a very common exercise is just outside the realm of the Open Records Act, usually, where then I would get back to the county attorneys to say, I think these three things should be disclosed. And they'd have a chance to push back, say, here's why you misunderstand it. And then ultimately you're brought into the loop as well. But I think necessarily there may be some ex parte communications as I try to understand what's going on. And then we make a record with you involved as to how I processed all that. But as I said, if I learn from threshold disclosure that it's 10,000 documents, then I bow out of that. That's not a proper role for me. And I think that addresses both things, in-camera review versus special master. We don't do both. We do one or the other. The in-camera review doesn't occur if it's too voluminous.
Okay.
So I may not have expressed myself clearly at the outset, or I may be misunderstanding you.
I don't think so. I just wanted to point out that, well, what I said is what I said, so I'll leave it at that.
Okay.
But I guess I'd also add to what you just said, though, that I don't think it's either or on whether you disclose or don't disclose. I think redaction is also a possible option.
Sure. I'm sorry. The either or to me was right now special master versus in camera. But you're exactly right. There may be this document right here, and the part that's super sensitive is this paragraph right here. It's redacted, and then the rest ought to be disclosed. I think that's fully part of it. The fact that there are 3 sentences in a document that might be privileged doesn't make the entire document fall within the ambit of exempt from ORA disclosure. I agree entirely. I didn't mean to say otherwise. The either or was, I'd like to try to handle this via in-camera review.
That makes sense.
You represent a nonprofit organization, and the county attorney represents a government agency. So we don't have big budgets to roll on. This isn't Chrysler suing Ford, where like, great, we'll hire 15 special masters to do it.
Okay, no, I agree with that.
Okay.
So I think you said earlier in your preliminary remarks that what our big concern is we don't have any confidence in the universe of documents. I mean, you found in the order awarding attorney's
Yes.
fees that they responded without doing a search and then didn't even do a search until after the complaint was filed. They don't have any records of what they searched. They say they didn't search even the cell phones of the 6 people that they knew were involved in some communication or dialogue or something with the January 6th committee. And then when you ordered them to do, I think what would have amounted to like the 5th search, when they previously said they don't have any records at all, privileged or otherwise, now they say they have some records that are privileged.
And we talked about this multiple times. They lied. It's not that complicated. They lied. They said they didn't have the documents. Oh, actually, we have the documents. They said that we don't have the emails. Oh, actually, we do have the emails and the communications. And we saw this with Ashley Merchant as well. She was getting all the attitude in the world from everybody, specifically Mr. Bond, that was on the stand testifying. And then it turns out they didn't do their job. Disgraceful.
It's just very difficult to have any confidence. Oh, and they said they didn't know how to use the Cellbrite technology to do kind of forensic searches, even though
That's
they have
what
that
they do.
technology and they presumably use it a lot. And
They do with every cell phone that they seize from a murder defendant.
Exactly.
Right.
So that tells me that there might be a technological issue. So we think a special master is going to be required for a couple of reasons. One is the horrible lack of confidence in their searching capabilities or efforts that they're putting into it. And if they turn over the 55 documents to you and you say, yep, those are privileged, fine, we're done. Like you said, there might be 5,500 out there that they should have produced and didn't. And then because of the apparent lack of knowledge, at least with the people that do the searches, of using this technology that they have available to them, a special master might be needed to provide technological support. And the person you appoint as a special master then might have to consult with somebody else on how to do that. But
Right, probably the latter. I don't know that we'll get someone from Microsoft as the special master, but you're right. We'd want to make sure, if we get that far, that we are empowering the special master to know what kinds of technical questions to ask. But I don't view that as insurmountable. There are white-collar investigation lawyers who are pretty savvy in that kind of situation.
I have every
I'll do it. I can figure it out.
confidence
don't
we
want
could
to.
find one or more people to do the job.
Okay.
But Rule 46 allows for a special master, and as you pointed out, it only says unless the statute provides otherwise. I don't think the Open Records Act provides otherwise. And the purpose of the special master would be to provide advice and information on technological issues related to discovery, which is one of the things we've got here. We've got basically what amounts to a discovery issue, and there's technology available that apparently isn't being utilized. And then also to monitor implementation and compliance with orders of the court, which is another issue we have, where the court has ordered a diligent search, and what was produced is the only one document that was produced was the one we gave them. So that didn't take much effort. And then we don't know, because of the many violations of the Open Records Act we've seen in the case, there's just no way to have any confidence that their search was thorough and productive and used all the technology available to them. So I think we need the special master, both because of technological issues and to monitor compliance with the court's order, because there's just no way to know that, especially in this case, that there has been compliance.
Okay. Mr. Bowman or Ms. Thomas, I'm happy to hear from either one of you. What are your thoughts about how we ought to move forward?
Yes, thank you, Your Honor. And to the point that you made earlier, we're looking at a universe of documents that we've been able to develop at this point. I don't have an exact number, but it's around 150 pages. It's not an excessive amount of documents, not thousands. We won't be bringing in bankrupt boxes or anything like that.
Have you had a chance to read any of the documents?
Yes, Your Honor.
All of them or some of them?
Been able to go through all of it, yes.
Okay. I don't want any substance in your response other than, yeah, it could be that way, or no, it's not. But one of the ways that I think I'll be able to address some of Mr. Monroe's valid concerns would be if one of the documents that you produce says, as we wrote in our letter from August 2, and in the universe of 150 pages, there's no letter from August 2. As you've done your due diligence, and I don't use that
That's
in a
funny.
freighted way. I'm not suggesting you've gone through and made sure there are no overlaps, but when you looked through those documents, did you have any concern that, well, wait a minute, they just internally they're referencing documents that aren't part of the universe of what was produced, and so clearly something's missing?
Well, Your Honor, there were
Could be the
two
case.
items that I noticed that I followed up on and got confirmation that no documentation related to the two questions I had existed.
Okay. All right. So in general, it was a fairly self-contained universe. The things that you received didn't lead you to say, well, gosh, this says 1 of 4 and we only have 1 of them.
Correct. Your Honor. Yeah, there was nothing that was certainly
I'm
obvious
not-
to me that there was something that was
I'm not
missing based
buying
on
it.
what was provided.
Okay.
And I got an update that it's actually 212 pages worth of documents. I think some of
This
them
just in.
are duplicative, as multiple people may have been on the same communications and have provided that
Okay.
in the suite, but District Attorney's Office has recognized the challenges that were created in this case and has taken remedial measures as part of following up on this order to conduct these searches. And they had searches conducted that consisted of relevant email addresses of those involved in the cases and investigations that were at issue here. There were a number of search terms to try and capture the entire universe. There were over 50 search terms entered across the various people included in those searches. Some of the
When you say searches, this is searching what?
This is searching emails in particular on
Got it.
these.
So if Jane Smith was someone who was represented to you, it'd be someone who would have been involved in communications with the January 6th committee, then a search was made of her work email for the word insurrection. And anything that had that word in it, you would have looked at and it's like, oh, she was shopping in a strange place versus it related to whatever happened on January 6th.
Along those lines, Mary, yes, searches such as January 6th committee, January 6th, Jan 6th, Jan.
Okay, I don't need all the search terms, but I'm just trying to understand. It wasn't searching for her name in her own email box. It was terms that the investigative team, whether that's from the county attorney's office or a joint team of DA people and county attorney people, terms that would be relevant to the nature of the inquiry from Judicial Watch.
Yes.
Got it.
And then physical files were also searched as well as phone searches. I don't know about the Cellbrite technology. That's something that I can confirm. And if there is anything, if it hasn't been done, we can do it and provide it to Your Honor for a camera inspection. If it has been done, it didn't turn up anything, we will inform the court of that. But there were significant changes, including the methodology used in the search from previous searches in this case.
Was your office involved in the searching, or what you're sharing with me is what has been represented to you by someone from the district attorney's office?
The latter, Your Honor, the district attorney's office conducted the searches.
Okay, so you're the vessel through which this is flowing. You're not the architect of the search. And I don't mean you personally, it could be Ms. Thomas or someone else who was sitting there saying, all right, I'm going to type in this search term and see what emails turn green on the screen because of that search term.
That's correct, Your Honor. And the district attorney's office is also prepared and agreeable to the in-camera inspection and willing to provide those documents to Your Honor.
Yeah, and I can imagine during this in-camera inspection, there's going to be a lot that they're not going to want to be brought in, which again wouldn't be surprising, and we're just gonna have to wait and see. I'm gonna leave a full link to this. Judge McBurney actually has a YouTube channel, so shout out to him. Y'all go subscribe and show some love to Judge McBurney. He's definitely one of the more entertaining judges, which I think a lot of them are here in Fulton County. I will leave a link to this full video in the description. Y'all let me know what you think about this in the comments and in the chat. Is there going to be a special master appointed? What's going to happen with Fani Willis moving forward? And hopefully Judicial Watch is going to put the pressure on Fani Willis and Judge McBurney to make this happen. We'll have to wait and see. Let me know what y'all think in the comments and in the chat.